Good morning. This is July 6, 2022. It is 9:01 a.m. We are beginning our council time agenda today with two work sessions. The first one is with the prosecuting attorney's office to learn about, on behalf of our residents and citizens, the case backlog in the prosecuting attorney's office. So I will turn it over to Mr. Tony Golick and your team. Thank you for being here.
Thank you, Chair. Can you hear me okay?
Yes, perfectly. Thank
Great.
you.
Great, thank you. So I wanted to have this work session to talk about backlogs in the prosecutor's office that have been created by a number of factors and take some time to talk about those things and advise the council about what has occurred with respect to COVID, and then what has transpired due to that, and then also equally, or perhaps more importantly, to discuss changes in the law that have occurred over the last few years that are really unrelated, that are going to create long-term effects on the justice system. So before the changes in the law that we're going to go into and COVID, our criminal justice system and staffing in the prosecutor's office, case filings in the prosecutor's office, they were really pretty static and pretty easy to predict. There would be some kind of minor changes here and there over the years, but our case filings, if you look back over the last 20 years, not that much change other than in the recession our filings went down, but then they came back up post-recession. We're talking a decade ago now, to sort of the same numbers. So we've averaged on the felony side for case filings between 2,000 and 2,400 felony cases per year, and that's been pretty static pre-pandemic. Fluctuation of 100 or 200 case filings generally per year. And then the amount of time that those cases took to work through the system was fairly static also, because there weren't any big significant changes. The jail was operating in a particular way for a long time, so the jail population, no big changes, no big changes in the law that affected how long it took to resolve the vast majority of cases. So like I say, there would be some fluctuation, but it was pretty predictable. That has changed drastically in the state of Washington due to, like I say, the pandemic, but also because of changes in the law that have changed the number of people that are in custody pre-trial and how that's handled. And that change has expanded the time that it takes to resolve cases in general. So I want to kind of go through those things to give the council a kind of a good high-level understanding of those changes and the impacts of those changes. So I have a number of our senior team leaders here with me that are going to talk about sort of each of those things, starting with impacts of trial suspensions and court closures, and then moving into the changes in the law. So the first person that I want to have present is Senior Deputy Prosecutor Lauren Boyd. She's the team leader of our Domestic Violence Prosecution Center. And she's going to talk first for a little bit about the impacts of COVID and the changes that that has created. So I'll turn it over to her, and then we'll move into changes in the law next. Lauren?
Thanks, Tony. Thank you for having me. My name is Lauren Boyd. I'm the team lead of the Domestic Violence Prosecution Center. I want to talk specifically about the trial suspensions that our courts have imposed due to COVID, and then also about how this specifically affects domestic violence cases and resolving domestic violence cases in a timely manner in our county. When the pandemic first hit, the court shut down completely for a couple of weeks until we could figure out how to get up and running with virtual dockets. That was a relatively short total court closure. The biggest impact that has been created by COVID, though, has to do with trial suspensions. These have occurred while the courts have been up and running, but they have suspended trials and not allowed any trials to take place. And that has caused quite an issue. We've had 3 very significant trial suspensions in our county. The first one occurred on March 20th, 2020, right at the beginning of the pandemic, and was originally scheduled to end April 24th, 2020. However, after seeing what cases were doing in our county, that trial suspension was extended to July 6th, 2020. So at the very beginning of the pandemic, we had about a 3-month period with no jury trials at all. We cannot do most of our trials by bench trial. It's the defendant's right to determine whether they want to do a bench or a jury trial. Almost exclusively, they choose a jury trial. So when the court suspends jury trials, that's effectively a suspension of all trials. The court then was open for trial mid-July of 2020. However, it imposed a ban on trials more than 2 trials per week. So at that time, we were only able to handle 2 trials a week in the courthouse. That, I think, was because of social distancing requirements. The jurors couldn't go into the jury rooms that are provided in the courthouse because they couldn't effectively social distance. They also couldn't sit in the jury boxes next to each other because they couldn't be 6 feet apart. So trials at that time had jurors spread out throughout the courtroom. Because of that, we couldn't fit any community members in the courtroom to watch trial, but community members have a right to watch trial. The defendant has a right to a public trial. So we had to utilize a different courtroom to project the trials into so that community members could come and watch the trial. The jurors then had to use a third courtroom for their deliberations and their breaks so that they could spread out and effectively social distance while serving jury duty. So practically, we were using 3 different courtrooms for every trial, trying to space different trials out by floor. We only have so many courtrooms and so many floors in the courthouse. So only 2 trials were going at a time. We also could not do jury selection in the courthouse. Jury selection requires, depending on the case, a significant amount of jurors, somewhere between 30 and 100 jurors to come in so that we can pick a fair and impartial jury. The solution to that was to do jury selection at the fairgrounds so that we could have jurors socially distanced and try to keep everyone safe. But that required a lot of complex planning and logistics. It was impractical to have jury selection at the fairgrounds on multiple cases going at the same time. So that also limited us to be able to do 2 trials at a time. That jury selection process and the process to only do 2 trials at a time extended until the middle of July of 2021. In the meantime, we had another court closure of trials, and that occurred starting November 25th of 2021, and went until the very beginning of, November 25th, 2020, and went to the beginning of 2021. We've had a third court closure since then that occurred at the beginning of this year and ended, from January 6, 2022, and ended at the end of February. Every time that we have these court closures, it pushes all of our cases off. Our older cases, then when the court opens up, need to go first. That pushes the newer cases out back further. At the very beginning of the pandemic, at least, and continuing through each of these court closures, have several cases. Each prosecutor has several cases that are set during the court closure that then need to be reset. So the defendants either need to come back into trial, or the court, at least at the beginning of the pandemic, because of the logistics, had reset many of our cases off the docket, and then sent the prosecutors and the defense attorney the notice about when trial was reset to. That had to occur many times at the beginning of the pandemic, at least, and throughout the case. That's caused a lot of issues with defendants necessarily getting notice of when their new trial is. We had several defendants who missed their trial dates, missed coming up to court because of the logistics of rescheduling their trial. And then we had quite a backlog. With only 2 trials being able to go, we've reset hundreds of cases to the same date, and the court can only handle two cases at the same time. We just couldn't get cases to trial, even though we were attempting to and calling cases ready. Practically, it was not something that the court was able to accommodate. We have also had effects because of COVID that have nothing to do with the trial court closures, and that is because COVID is still in our community. Members of the prosecutor's office are contracting COVID, members of the court are getting COVID, significantly jurors and witnesses and victims are getting COVID. We've had at least one trial that was mistrialed. It was in, I believe, March of 2021, that was mistrialed because a juror contracted COVID in the middle of trial. So that trial had to be mistrialed and then retried again with a different jury. We've had trials where, even though we've had multiple cases called ready and going, not enough jurors have shown up to be able to serve on jury duty. When that happens, that trial has to be reset, and we have to continue on. And that continues to push back every single new case that comes in, every single case that's not as old as the case that has been called ready for trial. We've had at least 3 this month, 1 this week, and several in the past, cases that have been called ready by our office and by defense, and we're ready to go to trial. And then over the weekend, either the defense attorney or the prosecutor contracted COVID, and so that trial has to be pushed out. So even though we don't have any court closures right now, this is still a very active situation. COVID is still actively affecting our ability to get cases to trial. Specifically in the DV context, this creates a huge issue. It creates a large issue for all of our cases. I'm most familiar with the domestic violence context. Our cases get worse as they get older. Victims move, they decide not to participate. It behooves the defendant to want to push cases out as long as they can in hopes that the victim will change their mind about prosecuting. So when we have these court closures that allow the cases to be pushed out, the defendants jump on those opportunities. DV defendants also don't like to admit that they've done anything wrong. I don't think anybody likes to admit it, but DV defendants in particular. And so when we give them a plea agreement that says, take this plea agreement or we'll go to trial, it means nothing to them if there's no trial at the end of the road. So we have had significant effects across the office, but also particularly in the domestic violence context because of this. The other issue that I want to discuss related to COVID is the defense ability to be prepared for trial, because they're getting exposed to and contracting COVID in the same rates as everyone else. It's affecting their ability to be ready for trial. We've had several instances, it happens on a weekly basis, where the state has attempted to call a case ready, and defense has shown up in court and told the judge that they are not ready to go. The court frequently doesn't really inquire into the reasons why the defense is not prepared for trial. My guess is that the court is trying to protect the record for the appeal. They want the defendants to have effective assistance of counsel, so they're granting these continuances over our objection. This has become more frequent with COVID because of the issues that I've discussed, and this further pushes everything back. Every time a trial needs to be reset, it creates more work for the court, for defense, for our office, and it greatly affects our ability to resolve our cases. If we can't resolve cases and cases keep coming in, we have less and less time to work on each individual case, and that's created quite a backlog. Thank you.
Thanks, Lauren. The next person that will be speaking is Dan Gasparino, Senior Deputy Prosecutor, Team Leader of the Major Crimes Unit. And Dan's going to talk about the Supreme Court case State v. Blake that decriminalized, well, actually the legislature subsequently decriminalized possession of simple possession of drug cases. And that case has had a massive impact on the justice system in Washington. So Dan's going to outline briefly that impact that Blake created.
Yes, thank you, Tony. Good morning again, counselors and fellow county employees. Yes, I'm Dan Gasparino. I'm the team leader for our Major Crimes Unit, but I used to run our drug unit for several years until about a year ago. And the Blake case in the Washington Supreme Court that Mr. Golick was referring to found the drug possession statute in the state of Washington unconstitutional. And that was back in February 25th of 2021, so not quite a year into the pandemic. And when that ruling came out, well, first of all, it essentially gutted our drug unit, but we had to immediately figure out what to do with all those cases. So, of course, it affected us in the short term back in February of 2021, where we were triaging dismissals, vacates of convictions, warrant quashes, et cetera. But we've seen second and even third waves relating to the Blake case and its impacts. Specifically, these have been triggered by, well, when it first came out, we thought we might get through this in 6 to 9 months, maybe a year, because we knew it was going to affect a lot of cases. But I don't think that everyone had quite a wide enough view as to how many cases this would actually affect. So like I said, there's been second and arguably third waves of cases that have come back before us, and these are all now closed cases, and that's triggered by sometimes the courts. The courts, we've found out, have been looking through their cases that have been resolved, whether it was by guilty plea or guilty verdict, and are citing motions on for us to address a situation if there was a drug possession conviction within that case. So it could have been one of 5, 6 convictions within the case, but we still need to recalculate the score based on that vacation of the particular drug possession charge. It's also being triggered by inmates in the prison system that are realizing that maybe one of their prior cases was a drug possession case, and jailhouse lawyers, things like that. And so we're seeing this now as these cases come back. It's generally individuals that are still in prison, so people that are in prison on fairly serious crimes because they're serving a decent amount of time. And so that can include the major crimes cases that I deal with now, but also any other case where someone received a significant amount of time, whether it be for the crime that they committed or because they have a significant amount of history. So it's important to mention, because these situations, when they come back, it's generally a case that we as deputy prosecutors didn't initially handle, so it's going to be several years old. And so we need to familiarize ourselves with that case, essentially starting from square one. So it's like receiving a new case. But these cases are generally, like I said, very serious cases, and so we have to recreate the file because as we move into electronic files, physical files go away or they're archived, and so we need to find the file and or recreate it based on the digital file that we have, learn what occurred in the case, calculate the new scoring or determine whether or not the actual motion is even valid, because many times, whether it be an attorney's motion or the defendant's motion, it's not valid, and it turns out that they actually are not subject to a resentencing, but we need to go through the analysis nonetheless, which is time consuming, having to again pull up this case, and you're not just going through the current facts, but you're going through the criminal history as well, and a criminal history calculation can take a lot of time, especially in a bordering county such as ours, where you have to make conviction comparisons with other states. Many times it's with Oregon. And so just because you're convicted of a felony in Oregon does not necessarily mean that that counts as criminal history points in Washington. So it's a huge undertaking when one of these cases comes back. Again, it's just like you're starting from the ground up. And so arguably, at least I can speak for my unit, the major crimes unit has smaller caseloads because they're bigger cases. There's just more involvement in each case. It seems to me, and I know this is anecdotal evidence, and I'll explain why, that these Blake resentencings that we're dealing with are somewhere between probably a third. I would guess that's a pretty good estimate, probably about a third of a new caseload, potentially half, but that might be overboard. But it's not counted in our numbers. And it's not counted in our numbers because our case tracking system's antiquated and those cases have been closed. So they're essentially categorized as closed, whereas in reality, they're sitting on my desk again. Sure, there's a stamp on the file that says closed, but they got reopened because of this Blake situation. I have to relearn the case. I have to attempt to locate victims, recontact the victims, explain to them what's happening, and prepare them for what might happen, and then write my own briefing to respond to the briefing that has been filed on the case. So research it, prepare it, argue said briefing, and it's essentially just a whole new case. And these are not, shown in our numbers, and so sometimes they get forgotten by those that maybe aren't dealing with them or haven't heard of them. But it's a significant, time-consuming situation with these Blake cases that are not. It did not go away in 6 months or 9 months like we thought it would. They just keep coming. As soon as somebody that's in the prison talks to the right person or whatever and decides that they want to file a motion, again, not always even a correct motion, we have to deal with it. So that's kind of what I wanted to say in relation to the impact that the Blake case has and is currently having and has had on our units. And so I appreciate y'all's time. Thank you.
Thanks, Dan. So, counselors, the two things that have been discussed so far, trial suspension, court closures, and the Blake case, huge impacts, obviously, on the system. Those are things that, we'll get through COVID one of these days. Hopefully there won't be another court closure, so we'll move through that. And all of that work created by the Blake case, it will end at some point. But the next things I want to talk about or have speakers talk about are changes in the law that are going to be ongoing. So Kristen Arnaud, our senior team leader in our general felony unit, is going to speak next about changes in the law with respect to bail reform and the ongoing impact, the impact that has had and the impact that it will have for the foreseeable future.
Thank you, Tony, and thank you to the council for giving us this opportunity. Like Tony said, I am the team leader in our general felonies unit that handles the bulk of the felony cases that you see in Superior Court. That could be anything from nonviolent property damage, theft of a vehicle, and it could go all the way up to a harassment, an assault two with a deadly weapon. So we handle Class Bs and Class C felonies, which are for the most part, the bulk of the cases that you're going to see in Superior Court. Prior to COVID, I'm sorry, I'm going to back away from the mic. Prior to COVID, the way that the Superior Court reviewed bail, even first offense felonies, most felonies came with at least some amount of bail. It may have been a nominal amount of $1,000 or $2,500 in bail, but most cases got bail at first appearance. Almost all of our cases were coming in as what we call hot arrests, which means they were booked by police officers the night before, and then they were going to be on our docket the next morning. A small fraction of our cases were summoned in, and when they were summoned in, the default would be if they appeared for that hearing, then they would be released on what's called supervised release without any additional requirement to post bail. COVID really affected that situation. There was no official change in the rule, but first, when COVID hit, we had about 600 people in the jail, and we had to immediately evaluate all of our cases to locate nonviolent cases that were in the jail and release them. At that point, we had a limited space in the jail due to COVID, and we had to determine which cases we were only holding because they had prior warrants or some other considerations, cases that were in the jail that maybe did not belong in the jail with COVID, because we wanted to make sure that there was space for the violent offenses and we weren't releasing anyone who was a risk to the community. The court also at that time indicated that they were going to change how they considered when bail was appropriate. So generally speaking, the rules regarding release indicate that there's a presumption of release in all non-capital cases. The rules also state that the court can only consider the following factors when considering whether or not to release or set bail. First, the likelihood of reappearance at a later court date. And second, whether there's a likely danger the defendant will either commit a violent crime or that they will interfere with the administration of justice. Before COVID, the likelihood of reappearance was a major factor the court would consider and played a big part in all decisions regarding bail in every case. During COVID, the court said that they essentially suspended that first consideration, indicating that whether or not a defendant was likely to reappear was not something they were going to consider on whether or not to set bail. Because of the limits we had on jail space, they were only going to consider whether or not they were a danger to the community or a danger to the victim, or there was a likelihood that they would interfere with the administration of justice while the case was pending. That has largely become a permanent change at this point. The court has shifted how they set bail, and that's largely because of COVID, because there was an increase in people would in fact reappear at later dates for the large part at the beginning of COVID. And additionally, there's just been societal pressures and political changes that have affected how the court views bail. And so largely what we're looking at now is the main consideration when we're asking the court to set bail is whether or not this is a violent offense, whether or not they have violent history, or whether or not there's a likelihood that this could turn into a violent situation. And so what we're looking at now is that whereas we used to get at least some bail on all felony cases, we are now, most of our felony cases with no history are going to be setting at supervised release, sometimes without even supervised release. They're just released on their own recognizant without having to check in, without having to report or indicate where they live. So what used to be a Class C felony, you would get $5,000, $10,000 bail, and now is released on supervised release. We've never been in a position where we are using incarceration or jail to resolve cases. That's never been our position. That's never been what we have asked for or what our purpose was. But the reality is that when defendants are released out of custody, the case takes longer to resolve. First and foremost, because all of our cases are on two tracks, either an in-custody track or an out-of-custody track. In-custody track, per the rules, is a 60-day clock for a trial. We have 60 days from their arraignment date to set for trial, whereas out of custody, we have 90 days to set for trial. All of our cases, when they appear at first appearance, whether it's in custody or out of custody, and then we set an arraignment date about 2 weeks out. And then at that arraignment date, we set every single case for trial, and there is often no hearing between that arraignment date and that trial date. That's either going to be 60 or 90 days or somewhere towards the end of that window on those cases. And I say that because it's important that we hear time and time again now that defense is appearing at that readiness date, indicating that they've never heard from their client, that they've tried to reach out to them. They haven't been able to convey the offer on the case. They haven't been able to talk to them about trial strategy. They haven't been able to talk to them about discovery. And that affects our ability to close the cases. Defendants are entitled to effective defense, and a defense attorney who has not been able to contact them, who has not been able to discuss their case with them, is not an effective attorney. If we were to try and push a case to trial after a defense attorney has said that, we are guaranteed to be overturned on appeal for ineffective assistance to counsel, which means that all of the time, the effort, the emotional investment from the victim, and all of the energy put into the trial, into the appeal, all of that would be completely wasted, and then we'd be back in front of the court in about 2 to 3 years down the road, having to retry the case. Retrials are incredibly difficult. You're dealing with now sworn testimony that if they deviate ever so slightly from, we have to explain that and deal with that. People's memories have faded because we're now 2 to 3 years down the road from where we last were at trial. Additionally, we have to then track down people who may have moved, may have gone somewhere else, or may no longer have a phone in service. So it's incredibly costly and difficult to then have to retry a case after an appeal, and that's definitely not something that we ever want to have to do. I say that because if a defense attorney is standing in front of the court at readiness, and as Ms. Boyd mentioned, indicating that they're not ready for trial, the court's not asking them a lot of questions about that. There's not a lot of inquiry into what efforts have been made or why the defendant is not in contact with them. There might be a reminder, we might get a reminder from the judges that they are to stay in contact with an attorney. That is a condition of their release, but we've never had someone who's revoked release because they haven't been inclined. In fact, we've had cases, I can think of at least one case off the top of my head where the case has been pending since 2019, I think, and every single time at readiness, the same, we're going through that same conversation that he's not been in contact with his attorney. She can't convey the offer. She can't discuss trial preparation. And so yet again, we need a continuance. And even after years and years of that, there's no change, or it's the same thing where if you do the same thing over and over again, you can't expect a different result. And we are, again, continually setting over that case and other cases, many other cases, because defendants are out of jail and there's no incentive to resolve the case on their part. Our offers have changed in COVID. We have substantially changed our offers, because before, when you had someone in custody and you made a 30-day offer, that was a great offer. They wanted to get out of custody. They wanted to resolve the case, and that was an appropriate offer in that case. However, now if someone's been released and we're asking them to do 30 days in custody, that's a significant change. Even if you're asking for 30 days on a custody alternative like work crew, that's still a significant difference. And that's a lower offer than what we would have made before, but it's not incentivizing pleas in the same way. So the ability of our cases to resolve in a timely manner is substantially affected by how we handle bail in our court and how we address bail. We're not asking the court, we have changed some of our requests. We are asking for no bail holds on cases where defendants are out committing additional offenses. But so far we haven't had a lot of traction with the court from that. We do have multiple defendants who are out committing 4 and 5 offenses before we can get them, can have the case held to the point where we might be in a position to talk about an offer. But our cases, unfortunately, have been languishing for a lot longer than they used to, in no small part because the fact now a substantial number of cases are out of custody.
Thanks, Kristen. The next person that's going to speak is Anna Klein, our Chief Criminal Deputy. She's going to explain the changes in court appearances by defendants and the changes from mandatory court appearances and the ability to file bail jumps to where we are now, and that change that, again, is going to be for the foreseeable future because it's due to change in the law.
Good morning, Council. Thank you for allowing us this opportunity this morning. Prior to 2020, there were many court appearances where a defendant was required to appear in court. Additionally, they were required to appear in person with their defense attorney. For example, they would appear for first appearance, for arraignment, for omnibus hearing, for multiple review hearings. They would appear at readiness and then at trial. And if they did not appear for those hearings, then the state could file a charge called bail jumping. when they were appearing in court with their attorney, that offered them the opportunity to communicate with their attorney about the case. The prosecutor would also be in court, and a lot of times cases would resolve right there on the docket because you would have all parties present in the room together. You would have the defense attorney, the defendant, and the prosecution, and a lot of negotiating would occur on those dockets, and cases would resolve. Since 2020, there have been a couple of major changes in the law. First, there was a case that came down in November of 2020 that changed what hearings the defendant was required to appear for. So now they are no longer required to appear after arraignment. They're not required to appear at all between arraignment and trial. And so if they fail to appear, the state is no longer able to charge them with bail jumping or ask for a warrant. Additionally, in 2020, our bail jumping statute was changed significantly and greatly reduced the state's ability to file a charge of bail jumping. So between these two things, the defendant is not required to appear at all between arraignment and trial, and there's also no consequence if they don't appear. We're not able to ask for a warrant, nor are we able to add a charge of bail jumping. And this has also limited their communication and contact with their defense attorney because they're not required to appear in court in person, and they're not really required to appear in court at all. So this compounds the problem that Ms. Arnaud was talking about, where we're getting to readiness and defense counsel has not had communication with their client, has not had the ability to go over a plea bargain with them, has not been able to prepare for trial with their client. And so this is causing increased difficulty in getting cases resolved, and then if they're not going to resolve, in getting them ready for trial.
Thanks, Anna. So all of the discussions so far have been about Superior Court and felony cases. The first couple speakers, as I indicated, were about COVID and Blake, and then the last two were about bail reform and the changes to who is in and out of custody and the expansion of time it takes to resolve all felony cases as a result of that. So the next speaker will be Katie Sinclair. She's our team leader of our district court unit. So non-felony cases in district court, misdemeanor and gross misdemeanor cases, and she's going to speak about the impacts of sort of the same things that we've talked about on the district court.
Thank you. And thank you to the council for having us. My name is Katie Sinclair, as Mr. Golick just said, and I currently run the district court unit. Just to give a little bit of background for those who aren't familiar with district court, we handle all gross misdemeanor and misdemeanor cases. It's also the unit in the office where new attorneys typically start. And not only new attorneys, but new administrative professionals with our office. It's kind of the training ground, and yet it's a training ground, and yet it runs different than Superior Court. If anything, District Court and Superior Court kind of compete for who runs their processes better, as Ms. Emery is very familiar with. And I think in a lot of respects, District Court did a wonderful job of handling the pandemic as best they could. And it really, I'm here to kind of talk about how that kind of all played into effect with our charging and kind of where we're at today. Historically, in district court prior to the pandemic, an officer would have an incident in the scene. He would make a formal arrest, and if the person didn't qualify for kind of an arrest at the scene and actually be booked in jail, which was rare in district court, usually you're only going to see cases get an actual arrest at the scene when it's a second or more DUI within 10 years, as required by statute, or an extremely assaultive person, or other factors at play. But most often, misdemeanors are cited. They're given an actual, they're formally arrested, but they're given a citation, or at least they were, for a district court date about 1 to 2 weeks out. Officers were allowed to direct cite. That is something that we have done historically in this county that other counties, some do and some don't. But the advantage of that is the officer in the field cites the person in with about a week or 2 weeks notice, and then the court receives copies of that paperwork, is able to send it to our office. were able to prepare a paper file at that time, get everything run, get all the reports drafted, run their criminal history, get it in our case tracking system, and then the attorneys can prepare the file for the arraignment docket. When March 2020 happened, when everyone shut down about March 11th, it was a complete shutdown, much like Superior Court, District Court shut down completely for a while. There were no in-person dockets whatsoever. I think, you know, if we think back to that time, processes halted mostly because we didn't know the impact of COVID. We didn't know how contagious it was. And I think the court wanted to keep the community safe, completely shut down to avoid any kind of contagion situation. As a result, though, when you stop court, even if it's only a few weeks, everything stops. And in district court, we run huge dockets. The judges average about 250 cases a caseload. And so in district court on our end, they have a prosecutor counterpart. And so I have one DPA who's handling between 200 and 310 district court cases, which is a ton of cases. However, they aren't the same weight as felony cases, and that's why they can handle more. But nevertheless, the volume is huge. So when you stop court for even a couple of weeks from having in-person custody or having people come in and handle their cases, it creates its own natural backlog because we can only do so much when the court starts back up again. From what I recall, and I wasn't in the unit at the time, the court did open up to virtual only because there were those left in custody. However, most people in district court qualified for that automatic release. If you recall at the time, because of concerns of spreading COVID, we were asked to release as many people as we could. Most gross misdemeanor cases, why people are usually being held is because they historically have an inability to appear at court. They've been put on warrants multiple times, and so the court's holding them as a way to kind of make sure that they appear at court. At that point, they're all let out. And so then all of a sudden they become out of custody and they get treated differently on priority list as those in custody, as Ms. Arnaud pointed out with Superior Court. They just get put on a different track. Not different, or not better or worse, just different, less priority, as one should, because they are out of custody. Their rights aren't being, they are being held in custody. So at this point, it also, by shutting down the court rejected any direct sites into court, and mostly because the officers, most CCSOs specifically, they would use these things called sector tickets, and on sector it allows them to select a date, but it didn't allow them to select a virtual-only option. And so the court administration shut down kind of the ability to direct site because it just wasn't an option to allow virtual appearances, and we didn't want people coming to the courthouse. Trying to limit as a public safety measure. So officers didn't have that ability to direct site. So they just referred all of these cases into our, what's called our queue at the prosecutor's office. And those are cases typically reserved for what are we call cold cases, cases where the officer's in the field and either they need to do follow-up or they're not really sure if a charging decision is appropriate. So they're referring to our office to really make that formal decision in charging. It's never historically been used for straightforward cases with, you know, out in the field with a breath ticket. Those were always direct cited. So the system that they put it in, an email program for WSP and the sector or the queue program for CCSO, they started just flooding our queues with their reports. It wasn't too long before the court, though, however, allowed the officers to basically mail in their reports to the court. And so dockets started to fill up again, although virtually. They started to fill up because officers were allowed to then stop using our cube and mail it in. However, and that's kind of the program that our unit relied on, was we've been notified by the court that the officers are now going to send everything to the court, kind of a hybrid system of what they used to do. So our office started processing those cases because the dockets started to fill up because the officers as a whole started sending everything to the court. However, there was, from what we know now, a small contingent who didn't get the memo and continued to just send all of their tickets and their citations to our queue without us realizing it at first. At some point, we do realize it. However, while that's going on, our unit is trying to figure out a new process on how to handle these cases, because historically everything was paper file, everything was done a certain way, and now all of a sudden at the blink of an eye we have to make everything electronic. with an antiquated case tracking system and basically, an H drive with a bunch of Word documents. And everyone has to get Adobe Pro and learn how to do these new forms. And not to say that we couldn't, we definitely have, and we do these processes now, but it just takes time. You have individuals who've been doing something for 20 years, and all of a sudden at the blink of an eye, we have to learn a whole new system. That in conjunction, the court itself, district court, had to learn new systems with virtual Zoom. District court's been very progressive in that they've been using electronic documents for years. Superior Court still likes to use paper forms. District Court's been great and progressive in the sense that they've been using electronic forms for years, so they didn't have to learn that. But they did have to get set up for these virtual court appearances. And on top of that, the defense bar also had to get set up for these virtual court appearances and our office and what that meant. And the reality is processes just take longer, and we're still seeing the effects of that. We end up with these massive dockets mostly because people are let out. Jail isn't typically an option. It's becoming more, an option now. The people are being arrested and detained for a brief amount of time. But as Ms. Arno pointed out, people just aren't being held at the same rate. And that's fine. It just impacts our ability to settle cases because when you have someone who's been out of custody, they don't necessarily want to serve their mandatory sentence of 30 days in jail and 60 days in EHC for their second and time DUI. It's not fun. And so it takes a little bit longer for their attorney to get in touch with them and try to get these cases resolved. And again, now we're in the situation where cases aren't resolving as fast. We have new processes, and these virtual dockets don't come without technical difficulties. And so it's not uncommon, and we've had this as of yesterday. We had a mandatory pretrial docket, which is their second in time. They appear at arraignment, and then they're set over to a mandatory docket, which dictates whether they're going to go for a trial route or a change of plea route. In most cases, they're set for trial. But that docket in particular yesterday took 4.5 hours. So they got out right before 1 o'clock. And so these dockets are just taking so much longer, in part too because the court, and I think it will continue that way because of equal access to justice. We want people not to have to spend hours down at the courthouse getting things done. But as a result, though, we are going to have people out taking a break at their work, and inevitably someone's going to run into a technical difficulty, and things are just going to take a little bit longer. And when you have a 78-item docket, an extra 2 minutes on each case really adds up. So as a result, we have individuals, the DPAs, who are on the dockets for literally half the day, and then some of these individuals have double dockets because the judges are trying to create more dockets to allow more people to be seen by the court, which is great, but it requires us to have an extra body. And then as of January 1st, 2022, we went from a 5-judge rotation to a 6-judge rotation. And although the overall cases haven't grown, it's just another judge rotation that we have to staff for, and then our administrative professionals have to prepare and help get us ready for. And so as a result, we just have kind of these massive dockets that have been going on in conjunction that we've also had these queues kind of filling up. And at no point was anything lost. It was just adding up, and it was a matter of dealing with kind of the priority right in front of us, which is we have an individual in court who has a case who's been cited on, and we need to address that case, and we need to address what the court needs from us today, knowing that there is also a number of cases that need to be addressed in our queue, which historically was reserved for cold cases. That too, some of these cases had to remain in that queue because we were waiting on the lab. A lot of officers in the field, when they would run into a situation where the person refused to provide a breath ticket, they would seek a search warrant and then get their blood drawn, which is a good decision of the officer. The downside, of course, is that our tox lab is behind, and so it's about a year wait. So if I have an officer who cites someone in the field for a DUI in September of 2021, we're probably not going to get the tox results until September of 2022. So that plays a role into our ability to charge cases as well, because even if we charge the case, defense knows that there's an outstanding blood result waiting to occur, and they don't really, and I can't blame them, they don't really want to resolve the case without knowing that for their client. And so that has to play into our role as well. The good news is everything is out of the queue at this point. We have a dedicated staff person who is working on preparing all the files, and I'm personally charging all of the cases. And so we're projected to be fully charged by fall of this year. Thank you.
Thanks, Katie. So I want to end this presentation on a little good news. You've heard kind of a lot of doom and gloom about the justice system. I would say the backlog created by COVID and Blake, will work through that. We just have a systemic change in the number of people that are held because of changes in the law. That's just going to make cases take longer to resolve in general, and we're just going to have to, over the next few years, sort of reevaluate, what the staffing requirements are for a given number of cases, given the longer amount of time for cases to resolve. So that's something that we're going to be talking about with you in the, in the years to come. But like I say, a bit of good news. So prosecutors' offices around the state have had these same problems. And there's been a lot of sort of talk in the media about issues with hiring in general and with law enforcement. And certainly you've heard from the sheriff's office a lot about staffing problems in the sheriff's office. Those issues have been very present for prosecutors' offices around the state also. A great number of prosecutors' offices around the state cannot fill deputy prosecutor positions. That was never a problem historically. Historically, deputy prosecutor positions were very sought-after positions by people coming out of law school or attorneys in general. Unfortunately, we have issues now in the justice system, and kids coming out of law school, they have different opinions about what they want to do as attorneys. So, I've been talking with my fellow elected prosecutors around the state at each of our conferences over the last several years, and a number of them they're just wringing their hands. They cannot fill positions. A number of them have had open positions for several years now. We have not had that problem in Clark County because of the office that we have and the really fantastic staff that we have, including the people that have been talking to you today. We've still been able to attract talent, and we've been able to fill our positions. So we've not suffered that issue. And in fact, with the support of this council and, getting the additional positions with COVID funding, we've been able to attack that backlog in a much more efficient way than most other prosecutors' offices around the state. And one other bit of good news, certainly you've heard a lot about auto thefts here in Clark County and across the state and what a huge problem that's been. So we have had a grant-funded auto theft prosecutor position for, I think, 8 or 9 years now in Clark County through WACPA and administered by WASPIC. So grant funding for an additional auto theft prosecutor has come up, and we have won a grant for another auto theft prosecutor. And I've been recruited to sit on the board for that statewide group that decides, where prosecutors should be dedicated. I was recruited for that because of the work that our office has done in working closely with law enforcement on auto theft cases. So that board wanted me to serve because our office has just done a really good job on creating auto theft task force and working on that, and so we've succeeded in getting another position. So some real positive news there, in that we'll be able to hire another deputy prosecutor, fully grant funded, to redouble our efforts on auto theft prosecution. So that concludes our presentation. I thank the council very much for indulging us to take some time to explain the changes in the law and kind of where we are now. I know that we're short on time, but if you have any questions, now would be the time.
Council, do you have questions? I'm sure that you do, and if we're not careful, this could go for many hours. So let's be judicious in how we proceed so that it is, I guess I should say, as concise as possible while getting to the point.
Madam Chair, can I start?
Yes, please, Councilor Medvigi.
And I really don't know how to be concise with all that we've just heard. This is a really important discussion for the community. and most of what we just heard probably went over the head of anyone listening. I don't know if the press is listening. I'm hoping they do some follow-up stories. So first and foremost, people want to know why crime is up, why it's out of control, why their cars and catalytic converters are being stolen, why there's rampant petty thefts and greater thefts. Why is there rampant criminality? You just heard why. These are some of these misplaced reforms are basically leaving recidivists out on the streets with no intervention by the criminal justice system. All good intentions for bail reform, some of the changes in the law, but they absolutely eroded the ability of law enforcement to do their job. So crime is up, and you just heard why. Now, so I appreciate hearing all the frustration by the prosecutor and his chief deputies, and kind of an overview of what's going on out in the community with this poorly misguided Washington State criminal justice reform. I appreciate all that. I had asked for an independent audit for very different reasons. I'm very mindful of everything that was just laid out, although I learned a few things that are very concerning to me. One of which, Blake, the legislature is trying to deal with, and the AG is trying to deal with how much money goes to each county to compensate the counties for having to pay out from the Blake decision. And what I just heard is our case management system isn't capturing those cases. So all of this is data driven. So I don't know how we're funneling these impacts for Clark County to the AG and to the legislature. So that's a serious deficit. So I have a real question about that. But let me get back to the point. I had asked for an audit, an independent audit, for two very specific reasons. This isn't an inquisition. This is all about what policies do we pursue, what funding do we provide, where do we leverage the county budget to ensure that the criminal justice system is properly functioning. What we were being told by some in the defense bar, by some on the bench, including the presiding judges. One, the PA office was announcing not ready for trial. That's, I was a career prosecutor for decades. That's anathema. That's the first thing you learn. Justice delayed is justice denied. The prosecution never announces unready. If someone's sick, you hand it off to a different prosecutor and you move forward. You need to get these cases to trial. So that was issue number one, and that was coming directly from the courts, who are saying we're ready and willing and open for business. The PA is announcing not ready. Issue number two, we are also hearing this from members out in the community, the defense bar, and the court. We have hundreds of DUI cases in district court lost in the system. So we're not talking about trials. We're talking about no first appearance, no filing, no appearance at all. You heard a little bit about statutory processing timelines. We didn't hear about the statute of limitations. But if cases don't proceed after arrest, after a time of transmittal to the PA's office, they get dismissed ultimately. So we heard that there were hundreds of those cases that people were afraid were just going to be dismissed. So I appreciate the presentation that was just done by the PA's office. My goal was to have all these issues out before the public, and hopefully give the view to the public of what our justice partners are doing, why some of this reform is not working. It's having the opposite impact. But most importantly, what is happening with our cases? Where are the filings? How many cases how many felony arrests were made, transmitted to the PA's office that resulted in a felony filing that resulted in a guilty verdict, by plea or otherwise? How many went by way of misdemeanor? How many went back to law enforcement for further investigation? What is the audit trail of the data behind the cases that our law enforcement agencies are bringing to the courts through the PA? So we didn't hear a word about any of that today, and I am disappointed. So I'm still going to ask that we have the auditor's office take a look at the data to see what's going on.
If I could respond to some of that. The first comment about Blake funding, I think that Councilor Medvedji misunderstood some of Mr. Gasparino's comments. The funding for Blake monies, all of the cases that where a person was convicted of a straight possession and they had to pay court costs, all of those cases had to be dismissed per Blake, certainly not our decision, and those costs had to be reimbursed. That certainly has been tracked. There's no issue with tracking there. What Mr. Gasparino was saying with respect to just our kind of internal work, those cases also, when you had a dismissal that affected offender score, a ton of people are in prison based on a sentence on an offender score calculation, so they had to be resentenced, which created a huge volume of work. And what Mr. Gasparino was saying there was just that case shows as a closed case, because it is a closed case, it's already been sentenced, but now it's coming back for resentencing. So it's not a new case filing, it's just resentencing of a whole bunch of cases that should have been done. And then with respect to that not ready comment, that's frankly, it's kind of offensive to hear that we're being accused of saying we're just not ready. I think it's sort of a term of art that is a Clark Countyism. So when we file cases, we get ready for trial in our office. We send subpoenas, we get ready, we're ready for trial. Cases are called ready because both the defense and the prosecution are ready and they're calling ready. So we can go in there all day long and say, we're ready for trial and we object to any continuance, but that doesn't really have any effect for the reasons that were explained in this presentation. If we just go in and argue the case should go to trial, even though the defense attorney is not ready, well, then the court's going to have to make a determination on whether they're going to grant the defense continuance. And if the defense is not ready because they haven't been able to do the things they need to do to get ready, that's what Mr. Arnault was explaining, that if the defense is unable to prepare and the court just says, well, you're going to have to go anyway, then the case is likely to get reversed because the defense was ineffective. So certainly nobody should be saying that our office is just showing up and saying, we're not ready. Sure, that happens sometimes where we're not ready because we have witness issues. Sometimes we have witnesses that, are not available, that sort of thing, so we actually have to ask for a continuance. But we are ready for trial on the cases that we file when they are coming up for trial. We are just generally having to wait for the defense to get ready so that we can actually try the case. And the fact that so many are out of custody is creating this issue of cases taking much longer to get to the point where they either go to trial or they're resolved. So that not ready thing is just not accurate. We are ready for trial on the timelines that, that cases come up for trial. So I just wanted to respond to that inaccurate comment.
Are there comments or questions from other counselors?
Madam Chair,
Yes, Counselor Rylander.
I truly appreciate all of the roadblocks and challenges and deviations that you've outlined and expressed this morning. On the other hand, I very much like to find, as I'm sure you do, solutions. So you've got a range of items that appear to be somewhat out of your control, but are there still things that we can collectively do or work on to have some impact down the road? But more importantly, what are the things that we can deal with on a local basis that are going to make a difference? And so I would be very interested in learning more about what you see as solutions, whatever those may be, because in the end, if we outline all of our challenges with the public really says, I don't care. What I want is a resolution. I want solutions. What do we have to do to make this right? That's at least within our line of sight, things that we can directly impact. So I would really look forward to more of a discussion going forward on solutions. Thank you.
Thank you, Councilor. If I could respond briefly to that. Certainly one of the biggest things in our community is the jail. We talked a lot about bail reform and how people are out of custody. That's also driven by the jail and lack of capacity in our jail. So, that's something that I've talked about, and certainly the sheriff has talked about. So that is a big issue with the justice system, and one that, our county needs to address so that we have more appropriate capacity in the jail. With respect to kind of all the things that I outlined, or that our team outlined, these are things that are issues for all prosecutors' offices around the state. If the council is interested in an audit of what our office is doing, I'm certainly always open to that. I have no problem at all with that. But that won't really solve the issues. The issues that, the things that are going to be positives to address these issues are staffing issues. Things like, getting that additional auto theft prosecutor into our office through grant funding. That's the sort of thing that is going to be a positive to, affect a positive change. Seeing better staffing in the sheriff's office is, something that we certainly need to see. The sheriff's office taking a proactive approach to auto theft in conjunction with our office recently. There was an article in Columbia that I'm sure you saw talking about the emphasis patrol that they did on auto theft in cooperation with our office. That's the sort of thing that, is a positive that we need to do, and we need to do more of that. I look forward to, hopefully being successful in hiring another DPA with that grant-funded position and be able to be more proactive in task force operations with all local law enforcement agencies on auto theft cases. But there's, all sorts of other cases, and, it's making sure that the law enforcement agencies are well-staffed and well-run. Doing audits is fine. I haven't heard anybody saying that they want to do an audit of law enforcement agencies that are having, the same sort of issues with staffing and difficulty in doing things. So I'm not sure what that accomplishes, but if that's what the council wants to do, that's fine with me, and we'll certainly cooperate.
Madam Chair.
Are there questions or comments from other counselors?
Yeah, Madam Chair.
Yes, Counselor Olson.
Thank you. So Tony, thanks so much for coming in today, and certainly thank you to you and your team. The last number of years has been difficult for everyone for all the reasons that you've outlined, especially in law enforcement, whether it's the sheriff's office or the prosecutor's office. I just want to, again, you don't have to be here. You're not obligated to present this information to the council. We have budgetary authority, but we don't oversee your office. I would not support any sort of audit. I think there has been some disrespect here that's a little bit troubling to me. I appreciate you coming, and I think it's important for the community to know the challenges that your office has been experiencing over the last number of years, but it's not our role to oversee you and your department. And I hope that that's clear to the rest of the council, that you're obligated, or you're beholden to the taxpayers and to the constituents who elect you. And ideally, we have a very good and cooperative relationship with you and your office. And I know we have in the past, and I hope we will in the future. But I just want to say thank you for being here, knowing that you didn't have to be. And I appreciate the challenges that your office has been going through over the last number of years.
Thank you, Counselor. I appreciate that. I'm aware of the separation of powers, and I think it's worthwhile to note. But I also, certainly want to be transparent with the council, and if the council has questions about what's going on with the prosecutor's office, I will be glad to answer those questions, and I think that's important. So I'm not going to stand back and say, well, you don't have control over the prosecutor's office. I intend to engage with the council if the council has questions. So appreciate that.
I have just a couple of comments and a couple of questions. They're all small in nature, but I wanted to start actually with thank you for mentioning the high intensity stolen vehicle emphasis that you and the sheriff's office worked on. I believe, was that in June that you did that? At any rate, it was recent.
I'm sorry, with what? I'm sorry?
The high intensity stolen vehicle emphasis that you worked on with the sheriff's office.
Right.
And I believe that was in June, and the sheriff's office reported that resulted in 18 stolen vehicles recovered and 32 arrests and so on. A firearm seized. It was just really a very good result for the community, and I just wanted to acknowledge that. Thank you, and say that we support those efforts and hope that they will continue, because we understand that sometimes those high intensity efforts have a yield that is not otherwise quite possible. So that's all good. I do have a question, and that was that you indicated that there are approximately 2,000 to 2,400 felonies per year that your office handles. What is the backlog currently on those felonies that you have been working with?
So the term backlog, I guess, can mean a few different things. So we traditionally talk about backlogs like in the number of cases that we still need to file. And then also that term can be number of cases that are in the system. You're always going to have cases in the system. And kind of what I was highlighting on is that they are taking longer to go through the system. With respect to backlogs, we had very significant backlogs in cases that were not being filed as quickly as normal, cases that were not hot arrest cases and were called intake cases. That backlog has been very, very significantly worked through. Like Katie was saying about district court cases, she's expecting by September for the backlog to be completely worked through and caught up in district court. In our general felony unit, we had somewhere around 700 cases in backlog status that were ones that needed to be filed. Now, we always have cold intake cases that are being worked on. That's normal, So I think probably somewhere around 100 would be a normal amount, because we have cases that are just referred by law enforcement. Sometimes it's a straightforward charging decision. Sometimes it isn't. Sometimes there's follow-up that needs to be done. So I think it's around 400 now in general felonies. So we were getting pretty close to current. It's starting to expand again in general felonies. Our major crimes team is pretty much caught up with backlog. Our domestic violence team, I'd have to get the kind of the most up-to-date numbers on that, but our backlog is starting to expand again in DV because of the reasons that Ms. Boyd was talking about in DV. In our Children's Justice Center, we had a very significant backlog. That backlog has been pretty much worked through, and those cases are all in the system. But that question of how long those cases are going to take to work through the system, that's kind of the unknown, because we are in this new uncharted territory. That was the beginning of my discussion here, was that, we had sort of general understandings about how long cases on average of different types of cases would take to work through the system, and that time is being significantly expanded. And that part's, there are going to be changes because things are getting much better with COVID now. We haven't had a trial suspension since earlier this year, and I'm hopeful we don't have another trial suspension. I think we won't, fingers crossed. And as the jail kind of gets more well-staffed, that we have more capacity there. So those things are going to be positives, I think, that will occur. But bail reform, those are things that have been enacted by the Supreme Court and by the legislature. Those things are in place, and unless and until the legislature or the courts change those will remain, and they will continue to make cases on a whole take longer to work through the system.
Well, and thank you. That brings me to the last area that I wanted to really discuss with you. I'm sure that your professional organizations are very active in working to try and bring changes through our local legislators and so on for bail reform and the after arraignment appearances and the things that you have mentioned as problematic. Council, as you know, also has those relationships with our legislators, and we have been this last year focusing on some that pertain more to the sheriff's office, because those were the ones of which we were most aware. We would be very delighted, as we are crafting the list of priorities for this upcoming legislative year, to add those issues that are of greatest concern to your office to the list of things that we are working for too with our legislators. And I don't know all of the specifics of what those would be, but we would like to know so that we can be specific in talking to our liaisons to the legislature to make those requests and to follow up on them and to find out the status of them. Where are they in committee? What's happening with them? And we're very active with those kinds of things and want to be, because it makes our county a better place. So if you would please help us with that, and I'm not suggesting that that be done today, because that is not something that has a turnaround time of 2 minutes, but would take a bit of time to put together well. But if we could follow up with you on that, we would be appreciative, and I hope that it would be of significant help to your office as well.
Thank you, Counselor. I would make a few comments with respect to that. In this presentation, I did not mean to, argue about the pros or cons of bail reform. What I intended to do and what we intended to do is explain the impacts of those decisions. There's been a lot of discussion, including in our criminal justice community and with the council, about the cost savings of bail reform, because it have fewer people incarcerated pre-trial, and the cost savings to the county of fewer people that you need to have in jail, and less need to spend resources on having a larger jail. And that's accurate. However, everything you do to the justice system when you affect a very significant change has other impacts, and that other impact of these changes to the law with respect to pretrial incarceration, bail, and the court's decisions on those you know, that impact is cases will take longer. I don't see this changing anytime soon, is sort of my read on that, Councilor. I'm certainly, you know, interested in making sure that, you know, people are looking at that and realizing that and seeing that impact. But, you know, certainly I'm also well aware that there is sort of, you know, great interest in having more people out of custody pre-trial. So I don't see I don't see easy resolutions to that. What I do see is definitely you know, longer times in cases, you know, creating more time for cases to resolve. So it's not an easy one to come up with answers to fix.
We understand, and that's why it's not a 2-minute turnaround on the answers to that. But working together, and we're as persistent as you are. So we'd be happy to tackle any issues that you would like us to in conjunction with your efforts.
Thank you, Councilor. I appreciate that, and I certainly want to keep this discussion going.
There would be
So,
one
Madam
other
Chair,
piece of
just,
information.
as a follow-up to that, you know, there is I think, a fundamental misunderstanding, at least on behalf of Councilor Olson, as to what I was asking for. You know, and I mentioned it in my introductory comments, that I understand we're not here as an inquisition or to manage the PA's office. If you recall, we passed a budget a couple of years ago that fundamentally revised the case management system for the PA's office. We recently did that for the Superior Court. When I mentioned the word audit, it was just basically to exercise those systems to answer the question of what is happening with these cases. You know, are there cases missing? You know, that was what I meant by audit. And it has nothing to do with internal workings of the PA's office or the challenges with our reform in the criminal justice system. It is a budgetary issue. We need to know whether the money we're investing is applied in the right places. We just funded 6 positions for the PA's office, and that fundamentally had an impact on eliminating the backlog in juvenile justice for filings. So these are budget issues, not internal
Juvenile?
working of the PA issues.
I'm confused about the comment you made about juvenile. Our filings are way down in juvenile. Were you talking about CJC, Council? Because you mentioned juvenile just now. Was that an error?
If you're referring to me, the 6 positions, are you referring to Dick Rylander or me? I was referring to the 6 positions to come up with our minor filings.
All right.
Sorry, just from a data standpoint, I would be curious as to whether you have a sense of what the court and the legislative changes have done to increase your costs in order to deal with the either additional personnel that are needed or the longer time frames, because that strikes me as the question is it an unfunded mandate? Have they pushed those down, and are they giving the money to the counties to actually help provide the budgets to take on the additional load? I would just be curious as to at some point whether there's a sense of what those costs are and whether we're getting help or we're just getting handed the bag to take care of as well.
Usually the second one. I don't think there was really much discussion at all, just like in the Blake decision, the Supreme Court, certainly there was no, discussion in that decision about, the impact on local prosecutors' offices. And I think with bail reform, really, like I say, a lot of the discussion with respect to costs in bail reform has been about decreasing costs on counties for incarceration in local jails, and that's accurate. You know, if you hold fewer people pre-trial in jail, that decreases the amount of jail space that's needed. That is accurate, and that there is a cost savings there. However, on the flip side, it makes cases take much longer. So there is the opposite effect with respect to costs to prosecutor's office, indigent defense, because you know, they're taking longer on cases also, and the courts.
And if I can, Counselor, we did have one-time money that was provided to the prosecuting attorney's office to hire 6 positions to help with the case backlog. And I don't know if Lindsay can speak to this as well, but we have received some funding for Blake as well to support indigent defense. I'm not sure if your office has received funding as well for that.
No, we received the Blake funding. We hired, I think, all the positions that we could at that time, and we didn't see the Blake funding as a good opportunity to hire positions because the timing was too short. So, you know, we kind of got as many people as we could, and we can only onboard so many people at a time. Katie's district court team is, you know, a lot of brand new folks there. So, you know, we've been able to hire positions. We've been able to fill those positions, unlike probably most other prosecutors' offices around the state. So I think that's the brief answer to that.
On the indigent defense front, it's a little bit different for us because we operate on a contract basis. So for Tony's office, they're looking at hiring real people for full-time jobs versus the indigent defense. We were able to just add to existing contracts, provide additional compensation for our existing contract attorneys to take on that caseload without worrying about having to, you know, terminate their employment when the Blake case is kind of fizzled out and we're done at the end. So it's a different setup for us.
Yeah, those resentencings, those are complex. It's not like we could just hire somebody for 6 months or a year to come in and do a bunch of significant resentencings. So it didn't really make sense for us to try to hire people with Blake funding. That does not mean that we have, you know, somehow missed, you know, any of the Blake refunding from the state for all of the money that needed to be paid back to defendants. That was a lot of kind of back and forth between the Prosecutors Association and the state on who was going to have to pay all of that money for all of the individuals that had their convictions reversed by Blake, all those people that had to pay legal financial obligations and all that money that needed to be refunded. That was a lot of money for, you know, every county, and our association is very successful in the legislature in convincing the legislature that in fact, you know, was something that the state should have to pay back, and we've certainly captured that here, and you know, haven't missed anything there, and that's being paid back by the state.
It is now an hour and a half that we have been after this topic. We thank you very much for your willingness to be with us and pursue, because you can see that we have a lot of questions. We know that residents have had a lot of questions. I believe there's one counselor that we have not yet heard from, so I'm going to ask Counselor Lentz not to put you on the spot at all, but to give you the floor if you so desire, just because if we're going to wrap this up and you wish to speak, we need to accommodate that.
Thanks, Chair. I say we just wrap it up.
Okay. Is there anything else that another counselor needs to say in order to bring this to a good conclusion? I think we are there. Thank you so much again, and we appreciate your office staff being with us. And we will follow up with you in the areas that we had indicated. probably by more email as opposed to this particular venue, at least for a good while. Again, thanks again.
Thank you, Council. Thanks for the opportunity to come and speak to you this morning. Appreciate it, and appreciate your interest in these important issues. Thank you.
Thank you.
And now we'll turn to our second work session